SJC-11706, Commerce Insurance Company, Inc., v. Vittorio Gentile and others.
Mr. Burke, when you're ready.
Please record just a moment more. Mr. Chief Justice, Associate Justices of this court, and may it please the court. My name is Brian Burke, and I have represented the interests of the defendants and appellants Doug and Joe Holmesy in both trial court actions and on both appeals. The chief question presented in this declaratory judgment appeal, however, is whether Commerce Insurance Company should be allowed to use an operator's exclusion form to deny third-party optional bodily injury coverages when by the form's language, by the language of related policy provisions, by language of applicable regulations in the AIB manual, and especially by the premium rate structure, it clearly was never intended to apply to such covers, and it cannot be reasonably read as applying to such coverages, except in complete contravention or derogation of basic insurance coverage law principles. Let me explain to the court how the operator's exclusion form was intended to work for Massachusetts automobile insurers and insureds. The standard Massachusetts automobile insurance provides manifold first-party and third-party coverages. Parts 7 and 8, collision and limited collision, the only coverages specifically mentioned in the operator's exclusion form by name, provide for first-party coverage for property damage to an insured automobile. The premiums for those coverages depend, because it's first-party, on the covered automobile's age, make, and model. The policy also requires that all household members be listed on the policy application or change request for setting the premiums on this coverage, because it's presumed that a household member will have access to the covered automobile. And if there are inexperienced drivers or drivers with a high SDIP step, the premiums paid for this coverage will be set higher because there is a greater risk in the event that high-risk household member operates the covered automobile on even one occasion. The operator's exclusion form, however, was designed to exclude high-risk drivers from being used to calculate collision premiums for one or more vehicles in a household, presumably high-end automobiles. In cases where, let's say, a parent of a licensed minor or bad driver owned a late-model Mercedes-Benz, and it would be cost prohibitive for the policyholder to pay collision premiums on that high-end automobile, given the presence in the household of that minor or bad driver, the Commissioner of Insurance approved this form so that a high-risk household member and the policyholder could both agree that the high-risk household member would never operate the insured automobile. It was not intended to allow insurers to prohibit non-household members from ever driving an automobile covered under a given policy. For example, when a minor grows up and moves out, as was substantially the case before December 7, 2004 with respect to junior Gentile, the insurer cannot charge a collision premium for any former household member. So the insurer certainly cannot require any signature on an operator's exclusion form from this non-household member. To hold otherwise is to give insurers outrageous degree of unilateral authority controlling the lives of insured Massachusetts families.
So if the rider says, I agree that this person isn't going to, the junior isn't going to drive any cars, what does that mean?
It means with respect to collision and limited collision coverages, the insurer can either deny those claims if that excluded operator,
So that would be first-party coverage that you're talking about?
no, yes, that would be first party, limited collision. It pays for damage to your
So
automobile.
it's first-party. So you're saying that that form never can mean third-party, it doesn't affect third-party at all? Is that your point?
Exactly, Your Honor. And I'm just about to explain why not.
Or any other part of the insurance policy, or any other coverage provided under the policy, even for first parties?
The AID
It's only collision and limited collision coverage?
I apologize, Your Honor, for interrupting. As long as the application of policy change request is made in good faith, and there's no question it was made in good faith here, Commerce's own agent recommended the change, and therefore to take Junior off the policy because he was no longer a household member or a customary operator under any of the vehicles. So long as that's the case, yes, this operator's exclusion form only applies to to excluded automobiles for collision and limited collision denial purposes.
But nothing else?
Nothing else, Your Honor.
And
At least not the triggered optional BI coverages.
I apologize if this is, I didn't see this point, collision, first-party, third-party, collision versus PI, covered in the appeals court case at all, is it?
No.
Was it Judge Garsh the underlying this?
Yes, Justice Garsh was the motion judge.
Did she, I didn't read her opinion, did she cover that?
No, Your Honor.
But you were arguing it?
Yes, Your Honor, because when Commerce presented their motion for summary judgment to the motion judge, their sole argument was that this operator's exclusion form was somehow a misrepresentation, that it was a fraud in the application for the insurance policy. And as we argued to the motion judge, that can't be the case, because it was made in complete good faith, and the judge so found, but she misapplied the Locke case to find continuing misrepresentation doctrine where no such case, where it is inapplicable. And on appeal, we said, look, the continuing misrepresentation doctrine isn't applicable. And the Massachusetts Academy of Trial Attorneys has backed us up on that. But we also said the only way this could be a possible impediment is if this was a condition precedent of the policy. And once I tried to distinguish how this wasn't a condition precedent in my principal brief to the appeals court, and then once I said it wasn't a condition precedent, Commerce comes in at the appeals court and says, well, it's a continuing representation, but oh yeah, it's also a condition precedent. So I've been trying to deal with the arguments that Commerce has made first only on the appeals level, which is this is a condition precedent, and if it is a condition precedent, it doesn't apply to anything but limited coverage and collision, collision coverages. And now I'm having to deal with a new argument that Commerce has made on appeal to this court that this is somehow a special warranty of a continuing promise. And just on that point.
So you were about to tell us why.
Certainly, Your Honor.
Why that even though they apparently breached their agreement and permitted this child to drive, that although they don't get limited and collision coverage, they would still get third-party coverage.
The premiums paid by Vittorio on the optional BI coverages were not affected by his grandson's SDIP rating, even if he were a household member. Therefore, when Junior was taken off the policy, Commerce had no right to charge Vittorio any additional premiums for this coverage based upon Junior's driving record. They would only be able to charge it unless Junior was a customary operator of these vehicles, and then only if Junior was an inexperienced driver whose classification would affect the step. But it was precisely because Junior was not a household member or a customary operator of any of Vittorio Gentile's vehicles, Commerce's own agent recommended that Junior be taken off the policy so that the premiums would be reduced. The exclusion in Part 5 says the only one applicable here, for injuries resulting from an accident while a household member, other than your spouse, is using an auto which you or any household member owns or uses regularly, unless a premium for this part is shown for that auto on the coverage selections pages. The optional BI exclusion prevents policyholders from insuring themselves on one vehicle and then letting other members of the household drive it. But the BI coverage exclusion only applies if the consensual operator is both a household member and a customary operator. That's different than collision. Junior was neither. Therefore, the Part 5 coverages triggered in this case are not affected by the operator's exclusion form for this reason as well. In the limited time I have left, Your Honor, I want to refer the court to the AIB manual. At least the AIB recognized that the only right an insurer had for violation of the operator's exclusion form was to deny collision and limited collision coverages. At 28.2, it's the second to last page of the addendum to our principal brief, Your Honor. It says, if any operator excluded as a result of such signed statement operates the automobile, the appropriate operator classification for the full policy period may be charged unless a collision or limited collision claim has been denied in accordance with the provisions of the policy because the excluded operator was driving the automobile at the time of the accident. If I may just finish this thought, Mr. Chief Justice. So the AIB manual itself draws this distinction. It allows an insurer at its election to either deny limited or collision coverages claims, first-party claims, if there's a violation of the operator's exclusion form. But it recognizes that with respect to all other optional coverages, the premiums are set differently, and the driving record doesn't apply. And Junior wasn't an inexperienced driver, so he wouldn't affect the premiums for optional BI coverage. That's the danger in trying to apply the operator's exclusion form globally, as Commerce has attempted to do, in derogation or in contravention of this court's holding in Heinrich Grundy versus Allstate, cited at page 45 of our brief. I thank the court for the additional time.
Mr. Chief Justice, Associate Justices, my name is Richard Urich. I, along with John Graceffa, represent Commerce Insurance Company in this case. This case arises out of what has been in existence in this Commonwealth for just about 30 years, 20 years as of the time that the policyholder and the junior signed the operator exclusion form. And that is the SDIP, the Safe Driver Insurance Plan. If you look at the appendix, page A106, you will see that the policy issued by Commerce specifically refers to the Safe Driver Insurance Plan. This is part of the regulatory framework which governs automobile insurance in Massachusetts. It has been around since 1984. Both insurers as well as insureds are bound by it. When an insured lists on an application various operators, he has to list both household members but also customary operators of the vehicle. The insured lists the operators. That is what happened in this case. When the insured lists the operators, then the regulations that govern the SDIP come into play. If you look at 211 CMR 92.13, which is page 31, 3 X's and 2 small i's, in the addendum to our brief, you will see how that works. When the insured lists the operators, the insurer then is required to look at each operator and to determine which has the highest step and classification rating so as to charge the premium on the first car in the policy. Paragraph 1B says that credit eligibility for the first vehicle on the policy shall be determined by using the surcharge information of the listed operator with the highest number of unsafe driver points. That's what happened here. Mr. and Mrs. Gentile listed Junior. He had the highest number of credit surchargeable points. As a matter of fact, the Court of Appeals, in the tort appeal in this case, specifically noted that the insurance agent had advised the Gentiles that this was the highest step rating he had ever seen, necessitating a very large premium charge by Commerce. Just a sidestep here. There is nothing in the record which, as Mr. Burke just alleged today, shows that this agent was Commerce's agent. This agent was the agent for the Gentiles. That appears both in the Court of Appeals decision for the tort appeal It also appears in the Court of Appeals decision in this appeal. The agent was not Commerce's agent. The agent was Mr. and Mrs. Gentile's. In any event, Your Honor.
I also heard him say that this was not a household member or a customary operator. Did you hear that?
I don't think he was a household member in light of the way that term is defined in the policy, but if the insured lists him as a customary operator, the insurer, Commerce in this case, has to take the insured at face value.
Oh, he
Here's
was
the list of
listed,
operators.
Okay,
You
so-
go through them, Your
Well,
Honor.
but then he was removed, right?
Yes. Then,
Okay.
once they have listed the operator, Commerce then charges the premiums based upon the surcharge. That's what brought this all about. The premium was horrendous. For this particular policy year, when the accident took place, it was more than $900 greater had Junior been on the policy. When the Gentiles saw this, they were astounded at the premium charge, and they asked their agent what could they do. Their agent said, if you sign this operator's exclusion form, if you sign this agreement, that will take Junior off the policy, and the premium charge will be reduced substantially.
Can I
Your Honor.
stop you there? Is there just a calculation of because I think your brother was suggesting that it was just affecting the premium for collision and limited collision and not affecting the premium calculations as to any other part of the policy.
I'm sorry, Your Honor. I think my brother is incorrect. If you were to look at the addendum in the amicus brief filed by the Automobile Insurers Bureau, addendum page 3, you will see that in paragraph C2, it says that if more than one operator is listed on the policy, the operators will be assigned to the automobiles in a manner which produces the highest combined premium for each automobile in the manner provided in paragraphs A, B, and C below. This is important, the next sentence.
Just let me interrupt you for 1 second. Is that in the record in this case? Or
It is the addendum to the brief filed by Automobile Insurers Bureau as an amicus curiae.
What is it that you're reading?
I am reading from the
document
the
itself?
manual of the AIB. It's Rule 28, 28C.
And
And
what
the text-
is that?
Your Honor,
What is that manual?
that is a manual put out by the Automobile Insurers Bureau to assist insurers in how all things that are regulated by the Division of Insurance, how these things are to be handled. This particular rule,
Is this binding on anybody?
Your Honor,
Is this binding on anybody?
yes, it's binding. It is approved by the Commissioner of Insurance.
Okay.
All these things are submitted to the Commissioner. He approves it. The insurance industry has to abide themselves by it. So also do insurers. And the point I want to make in this particular rule, 28C2, is this sentence which says, the combined premium is the sum of the premium for parts 1, compulsory bodily injury, 2, PIP, 4, uninsured, 5, optional bodily injury liability coverage, 7, 8, and 9, collision and comprehensive. So my brother's statement is incorrect. The premium affects also part 5, optional bodily injury. And what the Commissioner has approved is this operator's exclusion form to enable an insured, as the Gentiles did in this case, to reduce their premium by entering into an agreement that that person with a high credit rating surcharge will not, under any circumstances whatsoever, drive the car. In this,
I'm sorry to interrupt you. The operator exclusion form is created by the Commissioner of Insurance?
he approves the form. It was drafted initially by the Automobile Insurers Bureau, submitted to the Commissioner. The Commissioner approves it. It has operated in conjunction with the SDIP since 1984. And the form is on page A110 of the appendix. The paragraph that relates to collision and comprehensive, which Mr. Burke suggests is the only thing that this form regulates, is a paragraph, the second paragraph of the form, which is mandated by statute, Chapter 90, Section 34O, which deals with property damage. But the first paragraph talks about what is at issue here. What is at issue here is that the Gentiles agreed that their son, under no circumstances whatsoever, would drive any of the vehicles listed in the form, which was all of the vehicles they owned. They understood that. They agreed that. If he did do that, if that agreement was breached, then, as stated in the first paragraph, Commerce had the option to deny all optional coverages, which is what has happened here. This is something which the Insurance Division and the Commissioner of Insurance has devised in order to allow insureds to reduce their premium charges. And in return for the premium charge being reduced substantially, as in this case, the insurer does not have the risk of an accident occurring through the operation of a vehicle by an excluded operator. It's the basic concept of insurance. Insurance is a situation in which the insured, in return for the payment of a premium, assigns the risks, if you will, to the insurer. The insurer, in accepting the premium, says that should this risk occur, we'll cover it. In this particular case, this particular risk, any time that Junior drove the vehicle with anything that might happen, was removed from the insurer's risk. In return, the insurer charged less of a premium. This is something which has been devised by the Division of Insurance to enable insureds, on the one hand, to reduce their premiums, and insurers, on the other hand, not to have the risk involved with these drivers operating. If the Gentiles wished to have Junior covered and to have them covered under optional coverages, all they had to do was to pay the premium. Had they paid the premium, we wouldn't be here. There would have been coverage. But they opted to save themselves a substantial amount of money, and now after the fact, not necessarily they, but the Holmesies who have been injured by the operation by Junior of the car, are now saying that Commerce should not be allowed to enforce the agreement that is in existence between the Gentiles, the insureds, and Commerce. The argument seems to be that so long as no accident happens, the insureds can enjoy the reduction in premium. The minute an accident happens, well, it no longer is in force, and therefore the insurer has to pay. But that goes far beyond, as a matter of fact, that overrules and violates the precept of insurance. Insurers do not insure against, they cannot insure against a known risk. They insure against fortuitous events that might occur in the future. Here the argument is, the loss has occurred, even though they decided they didn't want that coverage, you nonetheless should pay. That's saying that Commerce has to insure a known loss. That's not the rule in this Commonwealth. For those reasons, Your Honor, what is involved here is a breach by the Gentiles of their agreement, the operation by Junior of the motor vehicle, causing a horrendous accident. But because of their agreement, there is no optional coverage. There is no Part 5 bodily injury liability coverage. Commerce's declination was correct. That's why it sought the declaratory judgment. Judge Garsh gave it to him. It was affirmed by the Court of Appeals. This court should affirm it as well. Thank you very much.
Thank you.
All right.